we'd like to ask is, why do you need these estate planning documents in place? And I think it's really important as we talk about that end of life moment, that you and the people around you know exactly what your wishes for healthcare are and who you want to make those decisions on your behalf. Now, this is one of those estate planning documents where, and I think Katie would agree, that I don't care how old you are. By the time you're of the age of majority, you should have these documents in place. As an adult, this is something that we both feel is really important and is a really easy step in getting your estate planning documents together. So let's first talk about what all of the estate planning documents are. And in general, there are 5 that are absolutely a part. And then there's a 6th one that, depending on where you're at, you might want to include in your basic estate planning documents. So we're going to walk through each of these documents individually, but those documents are wills and or trusts, a side letter of instruction, a durable power of attorney, a power of attorney for healthcare, a living will, and then finally do not resuscitate orders. So we're going to hop in and talk about each of these documents. So Katie, we'll pass it over to you.
Good morning, or I guess noon for those of you in Central Time. So a lot of people are familiar with wills and trusts, and briefly, basically, kind of explain. So wills and or trusts are documents that we use to distribute your property after your death. There is nothing that they can do. Trusts are different. Wills is strictly after your death, and kind of there's no protections for your health at all in these. And so the difference that a lot of people don't, that is hard to understand, is that so wills usually are required then to be probated through the court. So in the state of Nebraska, we have the probate system, and the court process then is to administer your will and distribute your assets. Trusts are created during life and then can be used during life, but are usually then set to the beneficiaries of what's supposed to be done or really not done with your property after your death. There's different types of trusts and all of that. The big thing is they don't, as long as everything's in a trust, you then don't have to probate them through the court process. But just a side note, everyone does pay inheritance tax. But wills and trusts really are what to do with your property after your death. We can put some burial instructions, but I'll be honest, they're not legally binding. So really, if you want, these are just property, and in the law in Nebraska, we've really divided what to do with your property and what to do with your health. So keep in mind, these are after you die, and then as we get through powers of attorneys, you'll kind of see why I keep emphasizing that.
Yeah. So the piece that goes along with that is a side letter of instruction, and sometimes your attorney will ask you to write kind of a letter to your executor or your personal representative. These documents have no legal standing. Again, they're basically outlining your wishes. And a couple of things that are important in this is you might include some funeral or burial instructions in the side letter of instruction, or you also might put in the location of important documents. But again, I think it's important as we talk about a side letter that it does not have legal standing. So of course, we hope that your executor or your personal representative would follow the wishes that you outline within this side letter, but is not legally binding.
So the first in kind of power of attorney document, so there's 2 in the state of Nebraska. We have what they call the durable power of attorney, which really works with your property. It appoints an agent to make property decisions on your behalf while you're still alive, usually incapacitated. I have a lot of people that come in and say, oh, well, my mom died, but I'm power of attorney, so I'm going to do this. That doesn't work. As soon as the person passes away, this document is no longer valid. Now, I personally think that the durable power of attorney and then the healthcare that we will talk about are more important than your will or a trust, because your will and trust deal with your stuff after you're gone. We want to deal with you and take care of you while you're here. So a big thing with the durable power of attorney that I have a lot of my clients come in and use is if and when they become incapacitated, then someone can do something like sell their house to pay for them to go into assisted living, or take control of the checkbook if they've become have dementia and something like that happens, so that way we don't have to get a guardian or a conservator. So if you don't have these documents in place, and say you have a stroke and you are no longer capable of making the decisions for you, we have to then, if you don't have a durable power of attorney, we have to create a conservatorship to designate someone to make those decisions for you. So that's why these are really important. I will tell you that the durable power of attorney can be written in a couple of ways. It can be at any point in time, so you can just give someone power of attorney, but usually we want it when you're incapacitated, which it's written different ways. I write mine so that you're deemed incapacitated by your primary care physician, and that you as the person can ask for a second opinion if you would like. But what this does is, a lot of cases that I am seeing involve dementia or strokes, in which it's not like it necessarily a clear line of when someone's not able to or able to. And so we've written it so that your doctor that you see and know, the benefit to small town living and small town healthcare, right, is they see and they know you and they want to take care of you as well. And so we get a letter from them saying you're incapacitated, then other people can be making your decision for this. There's a lot of things you can do with a durable power of attorney. So they are available for free online. I, not just because I'm an attorney, but because of the power they wield, suggest having an attorney help you fill that out and not just giving it, because if you sign it incorrectly or give them the authority to do things, then that person can change your will if you want, or they can sell your house while you live there and are capable. So the big thing about this is it designates someone so to make those decisions so that you get the decision made that you want made. A lot of times we have our spouses, and that's great, and the spouse makes the decision, but when there's just one spouse left, the decision kind of becomes, who does it go to then? And so that's what this designates, who, and then there's other decision papers that help you decide what, but this is for property while you're incapacitated. The other part I haven't touched on yet is you can be incapacitated temporarily or permanently. So I know during COVID, we had a lot of people that were temporarily incapacitated while they were on a ventilator, but recovered and are no longer incapacitated. So their kids had this to make decisions and pay their bills while they were in a coma for 10 days. They could get into everything, pay bills, and keep everything going. And then when they recovered, they came back to take this. So that's kind of why this is important, even though it seems silly. And yes, you can do it for free. And something's better than nothing. But I think going to an attorney really helps make sure that you're not giving away power you don't want to give away, or doing something that you're not aware of the consequences for. So the next one is the power of attorney for healthcare. And Nebraska split these apart, I want to say 10 years ago. I don't know. So some of you may have a document that covers both, and that's still valid if that's what you want. But in the separate ones that we are doing now, the power of attorney for healthcare designates someone to make just strictly your healthcare decisions. Again, usually while you're incapacitated. Again, these are only while you're alive. And then, so where this gets confusing for people is like, they're like, well, I want my power of attorney to decide how I'm buried or taken care of. They can't do that. That has to be in other documents. But this gives someone the authority to make the decision for you. what that is helpful in is if you don't have one of these, and say, usually it goes to your spouse, but if you don't have one, then it kind of goes to a vote amongst your relatives, whoever the doctors have at the hospital. So what we is hard to realize, and I'm a parent as well, and I have parents, is not everybody's going to be able to make the decision that you want made in a moment like that. So what I encourage a lot of people to do, and if I'm jumping ahead, Jessica, I apologize, is to think about who will make the decision that they want made. So my dad jokes that I am the power of attorney for healthcare for him because he knows I will be able to pull the plug and my brother never would. And that's what he wants made. And so a lot of times I know in Nebraska culture, in rural culture, it's like the firstborn or the firstborn son. Well, that person isn't always capable of making the right decisions in those moments for you, because it's really hard to know, like, oh, if I take my parents off of, if I don't elect to put my parents on a feeding tube, say, that they will pass away, in whatever way. And they're like, well, I don't want to do that yet. Well, the question is really, what would your parents want to have done? And so the really hard decision, I think, for these is deciding who to be that person and then what you want them to be able to do. So it usually does not include the right to refuse or end life-sustaining treatment. That's especially if you print it off of the free ones off the internet. I do write mine so that they can refuse end of life or life-sustaining treatment. We have to put in a lot of language for them to be able to do that. Now, the other thing that we can make these do, and why I still encourage you to go to an attorney, is I change those as people get older. So I have some people who get them in their 40s and 50s that want some life-sustaining treatment, dialysis, chemo, something like that. Well, as they get older, they don't. A big example I've had come in twice recently is I had someone who had dementia, late stages dementia, was in a nursing home, got diagnosed with cancer. If they had not had the power of attorney for the granddaughter or the daughter to say, we don't want chemo, they would have put this 87-year-old lady with dementia on chemotherapy because they have to do whatever is life-sustaining and like there was fighting amongst the family about putting this woman on chemo. And half the family wanted her on chemo. And luckily she picked the right person to be her POA that was like, no, we are not doing this. Like, she will not understand what's going on. She will not have any quality of life. Like, no, this is not what we are doing. Well, that is technically, could be life-sustaining treatment, right? Because she had cancer. So that's what this document gives people the power to do, and what you want. So some people want everything. Well, then we need to give them the power to do that. Some people want nothing. Some people want it to change. I did write one the other day that was like, it said, if I am of the age where this would be not just life like sustaining, but life fulfilling treatment, I want it. So that kind of like, but like if I'm 87 and in late stages dementia, I don't want a feeding tube kind of situation. But it gives one person the authority to do that. Now I have people who want me to do multiple. I usually won't. I will do a primary and a secondary, that if the primary is unavailable, that the secondary can step in. But I usually won't do co-POAs because that, in my mind, defeats the purpose of the POA. Because without one, your family can still make a decision, but they have to vote and agree. You need one person. And this one's, I think Jessica will have some conversations about like how to have these with your kids. But like as a kid and as a parent, thinking about your end of life and talking to your kids about that can be really triggering. It's difficult. It's uncomfortable. But we have to, if we want it to be executed correctly, because if you do co-POAs and they're fighting, then instead of taking care of you at the hospital bedside, we're filing for an injunction and arguing at the courthouse about your care. And so what these do is prevent all of that. The other thing I'm going to say, at least with this and with all of these documents, I joke a lot with my clients that the best gift you can give your kids is planning your own funeral so that they don't have to. one of the best gifts you can also give your kids is delegating the right person to be the power of attorney, and then following up with the supportive documents that Jessica will go into a lot more depth of, so that they know what decisions to make. So while we say that like a lot of these aren't legally binding, so the power of attorney for healthcare is legally binding. It is the ultimate in decision making, and as long as you are of sound mind when you make it, there is no disputing it. But it doesn't tell the person what decisions to make. It just gives them the authority to make them. The other documents are what tell them what decisions to make. And I have also been part of litigation where they thought they didn't pick the right person to be a power of attorney, and the siblings brought in these other supporting documents to say, you're not doing this right, you're not doing what mom wanted. And so then they actually got him ousted and one of the other ones put in. So I mean, that's kind of how these all work together. But losing, like having to take care of someone you love and make these decisions is really hard. I don't know if it makes it easier for people, the person that you do give the authority to make it, but it does help them in ways to make the decision that's right for you, because I think we all have different ideas of what we want done. But the other thing with the power of attorney for healthcare is I mean, Jessica will touch on a lot of other things that you can decide and how to decide those things. But those last moments and those last weeks, years, whatever, can be extremely difficult. I do know. And so this helps doctors. It just like it kind of puts everything into place. And then most of the ones for this one are the same. Incapacitated can be temporarily or permanently. So again, if you're on a ventilator and unconscious, someone can be making the decisions for you. When you come out of that and are awake, then you can make the decisions for yourself. But you have to live with the decisions that they made while you were asleep or in a coma or whatever. And so this can get really dicey. So that's why I think the biggest thing that I push for a lot of clients, and a lot of clients come with me to a meeting and have this listed out of who they want. And we have this kind of conversation, and a further conversation we'll have today. And then they come back to me with a different person that they're naming. And in that, forgot to say it on the last slide, it can be different people as your power of attorney for healthcare than your power of attorney for property. It can be the same, it can be different. I know people pick different ways. Some people, I just had a client who did a different daughter for her than her husband because they each have a favorite and they're afraid the favorite won't be able to make the decision to pull the plug. So it's the other one that's like, I mean, and I'm not judging any of those decisions. I am the power of attorney for healthcare and property for both of my parents because as an attorney, I am paid to make decisions because I'm a good decision maker. My brother, on the other hand, freezes and crumbles under pressure. And so I'm both. But we have people who have nurses in their family. So that's the power of attorney for healthcare, while other people are capable of doing the power of attorney for property. I think that's all I have on this one, Jessica.
Yeah, so let's pause for a second here, and we actually have a really great question in the chat, and it says, if you already have a POA with 2 agents but want to remove one of them, do you need to go to a lawyer for that?
I don't know if there's a clear answer to this. What I'm going to tell you is if you want it to be undisputable in like a court of law, then yes, I would go to a lawyer to have them edit it. Some lawyers will do it for a much reduced price. Some lawyers will, so like if you were returning to me to just take someone off, I'm not going to charge you what I would charge you to do the full power of attorney. Other attorneys may not be like that. I will be completely honest. You can always cross it out if you want, but if you want it to be like litigation proof, then I would go to an attorney to get it fixed.
And just to be clear, when we complete these documents, typically we're going to name a primary, and then we're, like Katie said, going to name a secondary. So only if the primary power of attorney is unavailable will the secondary be there. What she's not recommending is that you have co-primary powers of attorney. So you don't want those two people to have that opportunity to
Yes.
contradict each other. But we are going to list two people, but they'll be listed as a primary and then as a secondary.
Yes, thank you for explaining that. So for example, a lot of times people list their spouses as their primary, and then we want somebody else as their secondary because one of the spouses likely statistically will die before the other. They aren't, they don't usually go at the same time. And so, yeah, we want a primary and a secondary, but the secondary only steps in if the primary is unavailable.
And that's also a good reminder that if maybe you have these documents, and they've been drafted, but maybe you've had some big life changes, a death, a divorce, disability, something like that. We really need, and I appreciate the comment about, should we go back and review these documents? Yes, you should on a regular basis, and make sure that you still have named people, especially in these power of attorney slots, that can make the decisions for each side, for property and then for healthcare, and you're still confident in their ability to make those decisions.
Yeah, and
So
I would very much echo that. I've had a lot of, in my short time as an attorney, experience with this kind of stuff. And it's hard sometimes as a parent to think, would my child be good at this? But sometimes your kids have had big life changes and they're not in a place to make that. Sometimes they've gotten into some nefarious activities such as drugs or alcohol that they didn't have a problem with 10 years ago. And so the decision making is has changed. Or maybe you had your sister. My mom had her sister. Well, now her kids are 18, past 18, those kind of things. Yeah. And in kind of echoing that, and I should have warned Jessica, this has been my soapbox lately, and I don't know why, but your will is important. But even if you don't have a will in place, the state doesn't get your stuff, it goes according to law. If you don't have a power of attorney that's appropriate, like that really impacts the end of your life in ways we don't want impacted. And so people want me to visit their will to change their daughter's name who's gotten married and changed her name. And that doesn't really matter because as long as she was at once that person, then that's fine. Um, but this is really important. You have your sister or your brother on here who A, you no longer speak to, or B, is gone, or you have your son on here who's now an addict and has problems like that. We have I lose sleep over those kind of problems. I'm going to be honest with you guys because these people aren't being taken care of that they want to be. I don't lose sleep as an attorney as much over your property just because it's just, again, property. So yeah, if you want to revisit these, I suggest, especially if it's been more than 5 to 10 years.
awesome. All right, so let's get into really the meat of today, and that's talking about living wills. And you'll also hear these called Advanced Medical Directives. And this is where the hard work, I think, really comes and takes a lot of reflection for you as a person. We're going to be sharing examples of these documents or different ways that you can fill out these forms. But basically, a living will or an advanced medical directive outlines the situations and decisions under which you want certain care. So I think Katie gave a couple of really good examples. Do I want a feeding tube? Do I want hydration? Do I want dialysis? Those kinds of things in that scenario where I can't make those decisions for myself. And I think this personal reflection is something that I think keeps us from creating these documents of saying, well, I don't know what I want. But I think, just taking that time to sit with yourself and really ask yourself, what do I want? So this again gives the agent, the person that you gave the power of attorney for healthcare, guidance on what decisions to make, but does not necessarily give them the authority to make those decisions. So we really like this to be limited in the situation that you're proposing. You really want to think through each of those scenarios. The final document that we had on our list was a do not resuscitate order, or a DNR. And that basically says that you do not want the heart restarted after it has stopped beating. And typically we see these in much older people, or people who have medical conditions, that they've decided they do not want that resuscitation. And this is a really unique document in the fact that it requires a physician's signature on it. So again, we will talk about the 5. I'll put that list up here in a minute. But this 6th document really is typically for the chronically ill, or highly advanced ages. A physician usually will not sign a DNR without either one of those conditions being in place.
Is it,
So
Jessica, I was gonna ask, is it, when do, like, is it, when will, like, will a physician sign, when will they won't? So like, if you're just older, will they'll in a conversation, right? Like, they have an appropriate conversation about the consequences.
correct.
Okay.
So again, I don't know exactly if there are certain guidelines that they have for signing or not signing the DNR, but I will show you Nebraska's DNR document that you can discuss with your doctor, with your physician. So again, the 6 estate planning documents that you need to have in place are a will or a trust, a side letter of instruction, a durable power of attorney or a power of attorney for property. And then the 2 that we're really going to focus on today are the power of attorney for healthcare and that living will. And then we just briefly discussed the do not resuscitate orders. So as we've discussed already, that there are a couple of different options for completing these documents. There are examples that are out there that you can look at and kind of work with. So we're going to go back to Katie and talk about just working with your attorney and the process of working with your attorney through these documents.
So I know a lot of attorneys do things differently, but there's, I think, questions that need to be asked. So like, when you work with your attorney, right, you make an appointment. I usually like to have my clients come in. Sometimes I send a questionnaire, especially if they do email, and we kind of do the questions of just like what to think through their property, if they have pets, what goes on, do they have kids, that kind of thing. But I usually wait to have the conversation and kind of what I've talked about and give my little spiel in person. But so that first meeting for me, a lot of times, is just understanding where you're at, what you want done with your stuff. I know a lot of times people come in and they have an idea of what their sister had done or what they had done 20 years ago, which a whole different ballgame, but things have changed, especially when it comes to like Medicaid, Medicare, those kind of things since then. The biggest things that I ask is, or look at, what your job is to come to me with what you want the outcomes to be and how like you want your end of life experience to be. It's my job to figure out how we get there with the legal documents. So if you want one kid to get so much or not so much, those kind of things, then that's my job to kind of figure out. Same with these is, what of the documents do we need to make sure we have completed and in place versus, so like if you do need a DNR or want a DNR and say you're struggling to get your physician to sign off on that, maybe we need to have a meeting with the physician and kind of understand why. But my biggest thing is I want you to think about, and then what you want done, the uncomfortable part of it. And so usually for me, you come in that first meeting, we have this talk, you take week, 2 weeks, a month, whatever, to kind of think through it. We do the documents, and then I can't ever make my clients do this, but I highly encourage my clients to talk to their kids or whoever they've appointed or whoever is a recipient of their belongings to kind of talk through what they actually want done. Because the problem is, and a lot of people don't know this, I have had kids come to me while their parent is still alive and ask me what do they want done, and I can't break attorney-client privilege to tell them because their parent is still alive. It changes a little bit with a will, but not completely. And so if you have reasoning, if you have things that you've shared, like you need to share it with your kids or whoever you've made your power of attorney, your nieces, your nephews. That's the other thing I didn't mention, I keep saying kids because that's what a lot of people use, but whether it's not appropriate to use your kids or you don't have children, um, grandkids are always an option, nieces and nephews, friends, um, those kind of things. We caution late changes to the durable power of attorney to, the neighbor who then takes your house. But those kind of things are who the hard conversations to have, because either I can't tell them or they don't want to hear it from me. Um, so bringing in the thoughts and the ideas and having the goals, I guess, that you have for the what you want done with you as a person, and then your stuff while you're alive and then while you're gone. Because we have all these documents, we have other documents, um, those kind of things. It's kind of like if you want a mole removed, you go to the dermatologist and say you want it removed, and they kind of decide how they're taking it off. Um, I don't have it. That's kind of what we look for as attorneys is like, I know some attorneys, you just walk in and say, I want this, and they do that. For me and for a lot of others, we kind of want to see what the end goal is, and then we decide how to get you there kind of situation.
Awesome. All right, so what I'm going to show next are the documents that are available online. Some of these documents are available for free. Some of them are do cost. They do have a fee associated with them, but we're going to share those up, and you'll see on the screen, this is where those QR codes come in. And I'm going to be sharing these as well. So the first document that I think is actually very nice is the Nebraska Med Center does have an Advanced Care Directives brochure. I'm going to slide that over. Can you guys see that on the screen okay? Okay. So the Nebraska Med Center has a really nice little outline. Again, this is a document that you can complete basically on your own if you would like to. But what I would encourage you to do is to actually look at these as examples for when you go to talk to your attorney. So again, I agree with Katie that sometimes there are specific scenarios we would like written into that document, and these can kind of help you get an idea of what an advanced medical directive or a living will can look like. So on here, you can see it's going to discuss the primary agent and the secondary or alternate agent. So you'll notice that, again, we're not recommending two agents with equal power, right? We're saying if this person is unavailable, then the second person comes into play. So lots of discussion here, kind of fill in the blank type form. And then the second part is in regards to the healthcare as well as some spiritual wishes. Again, outlining some of those recommendations of end of life and then potentially for those funeral items. And then part 3 goes through the limitations of treatment. And I think this is where it really gets interesting of deciding, do I want specific types of care? And this goes through, we've talked about a few of them, but do you want a feeding tube? Do you want hydration? Do you want a breathing machine? And so that's outlines this. And then this one is interesting. It also includes organ and tissue donation, as well as medical or research programs, educational or research programs. So again, there is instructions here about how to make this a binding document. And again, you can do it this way. It is possible. If you don't have something on file, you can do this. Or again, you can work with your attorney. So the next document is the Nebraska Healthcare Power of Attorney. I'll slide this one over. This one is a little bit cold to me in terms of it doesn't really provide you guidance or help you walk through, what types of decisions that you can make, but just shows another good example of how you can outline those items. And you'll see that again, it assigns a power of attorney just for healthcare, a secondary person if they're unavailable, and then requires you to write in the types of treatment that you want. And I think this one's a little bit harder if this is a do-it-yourselfer, because it doesn't give you ideas of how you should do that on your own. So not my favorite in terms of giving you ideas or of scenarios to think through. So again, you can use the QR code on the screen, and these slides will be placed online so that you can look up those shortened links there. So that's there on the screen. The next one is the Nebraska Do Not Resuscitate Orders. And again, this is a document that is required to be signed by a physician, and usually only happens under a limited number of scenarios. So here's that document for you that you can look at. And again, you will need to work with your doctor to discuss these orders. So this is a printable document that you can print and take to discuss with your primary care doctor. This one is nice. I like the bottom of this one, where it discusses distributing this document, making sure it's included in the patient's file, whoever your primary care person is, if you are in home health or hospice, and then also placing it somewhere obvious in your home. So we'll talk more about all of these documents and how we need to discuss them. But this is one of those where if you need to print one off, your physician should have one, but you can print one and review it as well online. So the last document that is possible to complete that will include some of these components is called 5 Wishes. And if you complete the evaluation for today's webinar, I will mail you a free copy of the 5 Wishes document. And this document is a legally binding document. And what it goes through are these 5 kind of prompts. Who is the person that you want to make decisions when you can't? What kind of medical treatment do you want or don't want? How comfortable do you want to be at the end of your life? How do you want people to treat you at the end of your life? And then a section for what you want loved ones to know. So I'll slide over this example, and you'll see that it is a sample. Again, if you want a copy of this document, if you complete the evaluation, there is a slot for you to include your mailing address, and I will mail you one for free. And basically, this one has a lot more language in it in terms of what types of treatment, etc., that you want. It really breaks it down. Again, if it were me, I would look through this document prior to meeting with my attorney and have my attorney draft the document exactly how I want it. So again, it offers that. Wish 1 would be basically assigning your healthcare agent, and it gives you examples of how to pick the right person. And then it works through exactly what kind of information you want for your caregiver. So what does life support mean to you? And then goes through basically check marks, what I do and what I don't want as we go through. This idea of how comfortable do I want to be is an interesting section. None of the previous documents have really gone through this. You know, those kinds of things I think get a little bit more personal. And then how do you want people to treat me? You know, do you want to be visited by your local clergy? Do you want to die in your home? Those kinds of comments. And then the final one is how do I want my loved ones or what do I want my loved ones to know? So again, just really outlining, I will say going through this document is a little bit more emotional than potentially the other ones, because it really causes you to reflect through these statements. As we talk about these documents, I think one of the hardest things is knowing how to approach someone. Katie and I talk a lot about our parents, but we also need to reflect on ourselves and on our spouses, and potentially for our adult children, of how do we approach each other about this. And I think it's really important that while you are healthy and while you are of clear mind, that you develop these documents. Um, we always say, ruin Christmas and Thanksgiving by having these conversations. And so we would really encourage you, again, I think the most bulletproof way is probably to meet with an attorney who can work with you through these, but also reviewing then these other documents to get ideas of what can be done. So again, the 5 wishes document is something that you can fill out on your own. There is, sorry to make you seasick there for a second. There is a place for you to have it notarized or witnessed. In the state of Nebraska, it only requires the witness, but also then there's places where you can let other people know that you have a 5 wishes document. Again, if you would like one, you can sign up to get one within the evaluation of today's webinar. So those are where those documents are located. Again, we gave you several ideas. Again, we'll post the slides on our website so that you can get those links as well. So the last piece is sharing this information. And so we really encourage you to sit down by yourself, reflect on how you want to be treated at the end of your life and what kinds of treatment that you want and who you want to make those decisions on your behalf. We absolutely recommend that you share this information with your agent. Again, saying, this is not only, hey, by the way, I made you my, healthcare power of attorney, but here's what I think and here are my thoughts regarding that. You should share this information with your doctor. And I think this is really important because they're likely going to ask to include some of this information in your patient file. And so that's a really good way to share that information. There's also a national registry where you can place these documents online for your healthcare provider to be able to access them. So that is a possibility as well. So I see a couple of comments in the chat. The rest, we've got about 15 minutes left. So the rest of our presentation will basically be answering questions from you as the audience. So if you have a question, if you would place those in the Q&A or in the chat box, Katie and I would be happy to answer those for you. So the first question is, can I get the UNMC brochure again? Yep, I'll put that on the screen while we answer a few more questions. So here's the UNMC brochure. If you would like to scan that, again, the QR code, if you hold up your phone with the camera open, you should be able to tap on your screen and it will take you to this brochure. So that one is done. Let me dismiss that one. Okay. So the next question is, are all of these documents legal in all states or unique to the state of Nebraska? And I think that's definitely a question for Katie.
So both. So they're unique to Nebraska in, we have a few different things, but they are legal in other states. So the way I kind of say that is, you should have the POA drafted where you live, but because especially when it comes to property, that is kind of where it gets dicey, I guess. Healthcare, though, are transfer, as long as you did it legally where you're from, essentially. So where we live, clear out west, I have a lot of people who a lot of our patients get transferred to Colorado. We have never had any issues with this being valid in Colorado, as long as it was valid under the Nebraska laws. a lot of these, that's why we changed them about 10 years ago. A lot of the Western states are going to uniform type things. And so ours look a little bit different than Colorado. I'm also licensed in Colorado, so that's why I'll continue to speak on them. But it looks similar to the stuff in Colorado. It's not exactly the same, but as long as it's done validly in Colorado, in Nebraska, where you live, you should be fine. I have not heard of any issues in South Dakota. We have people go up to South Dakota as well. No issues there. I do not know about Kansas or Iowa for certain. They're both very similar, so I can't imagine there would be an issue. Now, if you are someone who, so I have a client who is seeking cancer treatment in Colorado. I did a POA for her for both. It just, for medical, it just made her more comfortable to have a Nebraska power of attorney and a Colorado power of attorney. The 5 wishes, those types of things are nationwide. Now, what each state requires for it to be accepted is different. I know Jessica mentioned only a witness in Nebraska. Well, Iowa might require a witness and a notary, so I would get both to kind of, I would do everything to the fullest extent so that it's valid. And the reason is, so like in the state of Nebraska, say your kids are fighting over who should be the power of attorney, they're going to have to fight that battle in the state of Nebraska. If that's where you're from and that's where the document's from, even if you're located in Colorado, Colorado's just going to say, as long as it's valid under Nebraska law, we're fine with it because that's where you're from. And as long as they're a lot the same, but you would then fight about that in Nebraska. And so that's kind of where you want it legal. If you are someone who's going across the borders a lot and would be more comfortable with 2, I know a lot of us that are located along the state lines are licensed in both. So you can, I have offered that to a couple clients where they get both just to make themselves more comfortable. But I've never had any issues in the state of Colorado.
So again, work with your attorney.
Yeah.
It's one of those, it's an easy question to ask of whether or not you would need more than one document. So the next question is, if you do your own power of attorney for healthcare, where should you file this document to make it legal?
So in the state of Nebraska, we don't file wills, trusts, powers of attorney, or anything. The only thing you would need in order to make it legal is that it fits the statute. So if you pull it off of the example that Jessica gave, that fits the statutes, and it just has to be signed and notarized. And you just need a copy of it. You don't file it anywhere. You just send it to like your doctor and your agent. That's the problem, is they're not filed, but you need them to be findable. So I was talking to Jessica earlier. I usually have my clients send it to their doctor. And then the doctor, again, we have a lot flown out to Colorado. The Colorado hospitals will usually ask for a copy of it, or that kind of information. And so that's kind of how we do it out here, but you don't file it, unfortunately. So it's wherever you keep it.
And I think that brings up a really great point, that as we talk about, these documents, that they need to be somewhere that your agent or your personal representative is able to access them. And it doesn't do any good to put these documents necessarily in the safety deposit box if nobody knows that you're there.
Or nobody has a key.
Right. And that's if when you're having this conversation, I think the next step of this conversation is, where will these documents be? Where will the most updated document be? One thing that I think is also interesting is, when you update these documents, you may also need to revoke an old one. We haven't talked about that, but making sure that all the documents are up to date, so that when something unfortunately happens, that personal representative or that agent knows where those documents are at and has access to them. I'll tell you a personal story. My grandmother's DNR is on her fridge. There's no question. There's no question of where it's at. And so that's something that, if especially if you are chronically ill or in advanced age, that whoever is going to be handling various parts of your estate is very aware of where these documents are at. They need to be somewhat secure, but they also need to be accessible, right? There is there's
They need
there's
to know the code to the safe.
yeah.
That's another one. We have the safe and we can't get into it.
So I think we kind of touched on this one. I'll just give you a reminder. We've got about 10 minutes left in our time together today. So if you have questions, please go ahead and put them in the chat or in the Q&A. If we don't have any other questions, we will wrap up a little bit early. So if you've got something on your mind, get those typed in. But this question asks, can your power of attorney for healthcare be from another state? So again, Katie, so let's say, for example, I have that in Kentucky. Does it apply here in the state of Nebraska?
Yes. What I would say though is it seems to be, and I haven't seen any cases on this. It doesn't mean there isn't in other states. I don't know of any out here or in surrounding states. If you've permanently moved, then I would suggest getting it to wherever you've moved to. And if you're traveling or sent somewhere else, they'll accept your home base kind of situation. But like if you've moved from Kentucky to here, I would suggest getting it because Kentucky law may be different than Nebraska law and you may not have all the requirements met. And all that does is slow down the process and makes it even harder for the people that are trying to make decisions for you. So if you want this to be an the easiest possible, because it's not going to be easy, then getting a Nebraska one would be the best, especially if you've moved. Now, again, traveling, whatever, we understand that, so it's fine. But the problem too would be if you're not in Kentucky, you're not under Kentucky law. So it just gets really complicated. I would just suggest if you've moved to get new ones. If you're just traveling, you're fine.
All right, I'm going to do a last call for questions. We do have a few minutes left. If you would like to shoot us a question, you can do that in the Q&A or in the chat. Just as a reminder that next week is Husker Harvest Days. So we will not be having a webinar next week. You can join us at the Big Red Building in Grand Island, and we would love to chat with you there. Ryan did put a evaluation link in the box. Again, if you would like the 5 wishes document mailed to you, you can enter your mailing address through that link that is now in the box. I'm not seeing any other questions come through, so I want to thank everybody for joining us today. A recording of this webinar will be posted at cap.unl.edu, where you can register for our other upcoming webinars. There was one that snuck in right at the end. So the question is, going back to wills, if you don't have a will, can you explain what the state will do? Is it a forced sale of or how is the property handled? We actually have an article for the person who typed in this question that outlines what will happen. And I'll give Katie, do you want to talk about in-estate
Sure.
succession laws real fast, and I'll pull up that article as well.
Yeah, so it doesn't go, it goes, instead of distributing as you want done, it's distributed according to state law. So I have minor children. I have 3 minor children and I have a husband. Without a will, the first $100,000 goes to my husband, then the rest of it is split in half. He doesn't want to split the assets in half. Like we want all of it to go to him. That's how it goes. So for like us, not that big of a deal. For somebody who's got adult children and they're on their second marriage, that seems to be an issue because they likely want all this stuff to go to the spouse instead. Another example of what it is the article explained this, but does it go per stirpes or by representation, which is a funny way of saying, like, if you have 3 kids and one has passed away and say they have 2 kids, if you go by Nebraska state law, if they've passed away, their share goes to in equal parts to their 2 kids with the other 2 kids. So instead of it being divided into thirds, with that third being split between the 2 kids, it's divided into fourths. So your grandkids get more than probably what most people want. Most wills, we put it per stirpe. So if this kid passes away, their kids get their share divided. It's not then divided into 4. That's a big one with farm families. So if your kids can't agree, can they force a sale? Yeah, they can always force a sale. I hate to break it to you. So unless you want a trust where we have other things going on, they can force a sale even with a will. So, I mean, it just, if you give property to children, to more than one person, the sale can always be forced unless it's in a trust. So.
Sorry about that. So I did go ahead and put Katie and I's contact information on the screen for you today. Again, we want to thank you for joining us, and a recording of this webinar will be placed online, and we look forward to seeing you at a future Center for Ag Profitability webinar series. Thanks for having us.